108. Should a release or separation agreement be prepared for terminating employees?
Companies sometimes opt for releases when separating an employee for cause or because of a reduction in force. When weighing the pros and cons of a release, consider the following issues. Is the employee a member of a protected class? If so, could that protected employee argue that he was treated differently or held to a different performance standard than other similarly situated, non-minority workers? Could a plaintiff attorney see any merit in pursuing a discrimination, harassment, or retaliation, for example, whistleblowing, lawsuit against your company? In a layoff situation, does your company have any plans to fill that position within the upcoming year? In a layoff situation, do your company's demographics, age, gender, and ethnicity, poorly reflect the demographics of those about to be laid off? In other words, could a plaintiff attorney argue that your actions might appear to negatively impact a disproportionate number of minority employees? If your answer to any of these questions is yes, then a separation agreement may be in order. Tell me more. First, remember that one of the key elements of any separation package is consideration. Consideration is the money or other element of value that you provide employees in exchange for their signing a release. From a legal standpoint, it is the inducement to a contract that validates the transaction. Therefore, you must determine first what appropriate consideration should be offered to the employee in exchange for the release. Second, remember that if the impacted employee is 40 years of age or older, special considerations must be given to that individual. Specifically, the Age Discrimination in Employment Act provides that individuals have 21 days from the date of notice to review and consider the agreement. Further, it must specifically advise employees of their right to seek legal counsel. In addition, employees must be given 7 days to revoke the agreement after they sign it. These 40 and over rights are incorporated right into the release. Third, when a group layoff is at issue, it is best to offer all impacted employees the right to a separation package in exchange for a release, above and beyond company severance. The reason is that, in addition to caring for your soon-to-be laid-off workers, you'll want to ensure that the surviving employees feel that you've handled matters fairly. After all, company layoffs occur when organizations are vulnerable. That means that employees feel vulnerable as well. Retaining talent is critical when companies are shedding staff, so do everything in your power to assure the remaining staff of your commitment to strengthening your business and treating people equitably. Appendix V is a sample separation letter including an Age Discrimination in Employment Act disclaimer. Note that this is specifically written for a financial services company in California. The purpose of the letter is to demonstrate what a typical release might look like. It should not, however, be copied word for word by your company for use in a layoff situation. Legal counsel should review your final document to conform to the rules and laws of your state.